rise, this court is now in session.
Thank you. Please be seated. We'll go on the record on KCR 22211624, State versus Lori Noreen Vallow Daybell. Mrs. Vallow Daybell is here represented by attorneys John Thomas and Jim Archibald. The state is represented by prosecutors Rob Wood, Lindsay Blake, and Rachel Smith at council table. The court understands that on the motions today, those will be argued by Mr. Wood and Mr. Archibald. The court would remind the parties in attendance here that the court's order regarding courtroom conduct remains in effect, including the prohibition on non-authorized video and photography by any members of the gallery. So if anyone has a cell phone active, please turn that off. You're not permitted to record or video any of these proceedings today. There are several motions or matters to bring up before the court. I'll indicate on the record we previously met in chambers briefly to discuss a few of the preliminary issues. The court wishes to put those on the record. The first matter we bring up wasn't formally noticed for hearing today, but in the interest of efficiency, I think it's worth calling and getting on the record. So, Mr. Archibald, there was a motion filed entitled Motion for Defendant to Appear in Street Clothing. The state did file a notice in response to that. If you'd like to just present that on the record at this time, you may.
Yes, may I remain seated?
You may. And Mr. Archibald, for you and also other counsel here, in order to best get our record with these microphones, it is best actually if counsel remains seated to speak into the microphone. So thank you, Mr. Archibald.
Thank you. Our motion for Mrs. Daybell to appear in street clothing is something that the court has granted previously. We appreciate the courtesies of the court and the sheriff in allowing that at previous hearings. We didn't actually have a written order, and so it was agreed upon between counsel that we get this in writing, and I'll submit a proposed order. We do appreciate the court being sensitive to my client's right to a fair trial, a fair and impartial jury. Having her appear in street clothing helps with that. So would ask that motion be granted.
All right, thank you, Mr. Archibald. What's the state's response on that, Mr. Wood?
Thank you, Your Honor. As the court is aware, we did file a response, a notice of essentially non-objection based on the circumstances of this case.
All right, thank you, Mr. Wood. The court's considered that motion. Typically, that's obviously right. It's allowed in front of jurors in a jury trial to prevent the appearance of anything that would run afoul of the presumption of innocence in the case. It is somewhat unusual to have an appearance in street clothes for pretrial motions of a defendant that's in custody, as Mrs. Vallow Daybell currently is. However, that's been the process we've used throughout the case. It hasn't been brought before the court for any formal ruling on that. Generally, the issue of how someone is dressed, really, for me, I defer to law enforcement and whatever they believe is appropriate for security purposes within custody defendants. Based on the motion filed by the defense and without an objection from the state, I don't see any reason to deviate from how we've already handled all the prior hearings in this case. So in order to confirm that on the record, I will grant an order, Mr. Archibald, and future pretrial motions if your client so chooses, and it's permitted and allowed by law enforcement authorities that are involved with her custody and transport, then she can continue to appear in those street clothes if that's what she wants to do.
Yes, thank you.
All right, thank you, Mr. Archibald. Next motion we'll call up is the motion filed July 12th by the defense entitled "A Motion to Incorporate Federal and State Constitutional Grounds to Support or in Support of Future Motions." Don't believe there was any specific response to that filed by the state, but I'll allow an oral response at the hearing. Mr. Archibald, if you'd like to present arguments for that motion at this time, you may.
Your Honor, this motion is based upon the death penalty jurisprudence of the United States. As the court knows, death penalty litigation is voluminous and is ever changing. In 1972, the United States Supreme Court said that the death penalty was cruel and unusual punishment. So states began to modify their death penalty statutes to conform with the United States Supreme Court's definition of what is not cruel and unusual. So since 1972, since the Furman versus Georgia case, there every 5 years or so in death penalty litigation, there's a change of rules. The United States Supreme Court, since 1972, has said no death penalty for those who are insane. No death penalty if a judge issues it. It has to be a jury. No death penalty for those who are mentally retarded. No death penalty unless there's a mitigation investigation of the defendant's life. No death penalty if the defense lawyer does not thoroughly investigate their client's life. And no death penalty for juveniles. So in our motion, we set forth several federal decisions that have been rendered regarding the death penalty in the United States. And for purposes of future appeal, we always have to prepare for the worst. And in case she is convicted, and in case there is a death verdict, this case will be on appeal for decades. And so we are making the record clear that we want all of our constitutional arguments preserved. We want all of our constitutional issues litigated in the future. Me and Mr. Thomas will not do any future appeal. There'll be other lawyers appointed to represent her in case there's a guilty verdict, in case there's a death sentence. So this motion isn't just what if, it's real. And in fact, a federal judge in Idaho just ordered a new sentencing hearing for Robin Rowe, who's been on death row for 30 years. And so this is an important issue. It has to do with this case because we know that 30 years from now, there's going to still be litigation ongoing if there is a death sentence. So I won't be around 30 years from now. I don't know if Mr. Thomas will, but this case will be if the state gets their request. So that's why my motion was filed. That's why it's important to us for the court to acknowledge all of her federal and state constitutional arguments are preserved.
All right, thank you, Mr. Archibald. Mr. Wood, what's the state's response on the motion to incorporate federal and state constitutional grounds, future motions and objections?
Thank you, Your Honor. Insofar as the motion is essentially a request that the court recognize that the defendant has not waived any of her constitutional rights, we have no objection to that. In regards to the practical application of it, the state does not object to it as long as the objections that are made are still made pursuant to the rules, that they state the purpose of the objection and cite to the specific authority that the defendant would be referring to.
All right, thank you, Mr. Wood. Courts considered this motion. It's the motion that was filed on July 12th to incorporate federal and state constitutional grounds in support of future motions of objection. Based on the argument of counsel and review of the briefing cited case law, which is substantial in terms of case law of the motion, the court will rule as follows: that in lieu of an order, I'm not going to order that there's some standing continuing objection. However, I'll make a express finding on the record that this particular defendant, Mrs. Vallow Daybell, has not, at this point in the case, ever waived any constitutional rights that are provided for in the Idaho Constitution or the United States Constitution. That she continues to assert all of her constitutional rights in the case, and that will be an order that you could submit, Mr. Archibald, in response to your motion. As Mr. Wood indicated, if there are any still specific objections to be made on constitutional grounds, I wouldn't consider that some sort of a standing order that would relieve the defense of the duty to bring those specific objections on the record. So there would still be a requirement if you think some specific constitutional right is being infringed upon by either the state or motion of the court, and those objections would need to be preserved on the record. But we'll acknowledge at this point that there's been no waiver of any constitutional right in the case. Any questions on that ruling or anything I need to clarify on that holding, Mr. Archibald?
No, Your Honor. Thank you.
All right, thanks. That will bring us up to our third motion then. This is the motion entitled "The Motion to Clarify Media in the Courtroom." That motion was filed on August 30th, 2022 by the defense. The state filed a concurrence with the motion on September 12th, 2022, agreeing in large part with the argument brought forth by the defense. And in response then, Attorney Steve Wright also filed an interested person's third-party media response on September 8th, and the court recognized the standing of Mr. Wright on behalf of the clients that were set forth in the caption of his pleading to be heard at this hearing today on behalf of his clients. So I'll hear argument in support of that motion first. I'll then allow the state to join in their concurrence, and subsequent to that, Mr. Wright, if you'd like to present your argument in support of your clients that are identified in your pleading, you can do that. So, Mr. Archibald, if you'd like to proceed with the argument this time, you may.
Thank you. This motion was filed due to what happened at our last hearing. Of course, there is no camera in front of our desk now staring at us, so I appreciate the media's courtesy not putting another camera there. I notice that there are not any microphones attached and on this desk as they were at the last hearing, so again, I appreciate the media's courtesy not doing that again. That was the issue that happened at our last hearing. All of us here, the prosecutors, the court, me and Mr. Thomas, we all have the same obligation to Lori Vallow Daybell, and that's to make sure that her constitutional rights are protected, including the right to a fair trial. The court, in its order governing courtroom conduct, has that as its first goal, that we need to preserve the client's, the defendant's right to a fair trial. The court was concerned about pretrial publicity last year, taking up the issue of a change of venue. So almost a year ago, this case was transferred from Fremont County to Ada County, over 300 miles from here, due to media exposure, due to the incessant, non-stop media exposure. It is necessary, we agree, to inform the public of what's happening in the case. Fremont County, however, is going to spend more for a fair trial because of the media's incessant, non-stop exposure of this case. So as the media exposure increases, so does Fremont County taxpayers, state of Idaho taxpayers, so does their obligation to make sure that my client gets a fair trial. So if the media saturation continues in Ada County, where are we going to go? We've already moved it 300 miles away, but the media exposure is hitting Ada County. So I've been a lawyer over 30 years. I've never had a problem with the media during any of my cases. I've never had to bring a motion regarding media about where they put their cameras or where they put their microphones. I've tried almost 100 jury trials in our district. I've been assigned to over 25 homicide cases. And the media has always been respectful. They know that I have a difficult job. I know that they have a difficult job. And we've been respectful of each other in our roles to the public. Freedom of press is a constitutional right. It's in the Bill of Rights. And it's not infringed by limiting cameras. And we know that because the United States Supreme Court doesn't allow cameras. Federal courts don't allow cameras. Some states don't allow cameras. And so the court wants the public to know what's happening, but yet the overriding interest is a fair trial for the accused. My client in the Bill of Rights enjoys the presumption of innocence and not a presumption of guilt. The state has to prove guilt beyond a reasonable doubt to a fair and impartial jury. So because of the pretrial publicity, is that turning the tide? Will my client have to prove her innocence at a trial rather than the state having to prove her guilty? So because of the media saturation, we filed this motion for the court to take a look at its order and how the media is acting. I've never had a problem with the media in the jury box. I've never had a problem with the media on the front row. Again, they've been respectful of me and my client, and I've been respectful of their job. But at our last hearing, I want the court to review that, but I tried to download it on a flash drive. I wasn't able to do that. But the link is mentioned in the state of Idaho's response. So I believe we all, counsel and I, agree that the court can look at that as to what happened at our last hearing. There was one camera on the judge, there was one camera on the courtroom, and there was one camera on Lori. Our hearing wasn't quite an hour long. It was a little over 50 minutes. And 30 minutes of that, Judge, was zoomed in on my client. What was the purpose of zooming in on her for 30 minutes? She didn't make an argument. All she did was whisper to her lawyers. What's the point of zooming in on her? There is no point. It was an abuse of the privilege that the media is given. Why did the media want to zoom in on her for 30 minutes when I think the lawyers and the judge talked for 50 minutes? The cameras were on the court for about 3 minutes. And that's, I don't know of many judges who want the cameras on them, so that's probably all right. But why wouldn't the cameras be on the attorneys for arguing rather than zooming in on my client? What was the purpose of that? She'd been in custody now for over 2.5 years. 20 months of that in a jail, 10 months of that in a mental hospital. What's the point to mock her, to make fun of her, to humiliate her? Does it have any value to the public other than to prejudice potential jurors against her? No, no value at all. So does it help the court find a fair and impartial jury in Boise when they zoom in on my client's every facial expression? No, it doesn't. The public will eventually hear of my client's mental health diagnosis. I know what it is, the court knows what it is, the attorneys know what it is. The public will eventually know that. And there's a time and place for everything, and that will eventually need to be disclosed. And so banning the cameras is a pretty drastic remedy in this district. And it's not the first time that the request has been made by an attorney in a high-profile case. For example, a few cases where cameras have been banned altogether. The case against Timothy McVeigh, the bombing in Oklahoma City. The case against Susan Smith for the murder of her children. The case against Richard Davis for the murder of Polly Klaas. And Scott Peterson for the murder of his wife, Lacey. So there have been incidents in high-profile cases where the courts have said enough. No more cameras. We'll give the information to the public some other way other than through the camera. And so I know that's a drastic remedy, and that's why I asked for an alternative in my motion. Let's go back to the way we've done it here, for at least as long as I've been trying cases for 30 years. Cameras in the jury box or on the front row, the spectator section. No humiliation, no making fun. And let's be respectful of each other, of our difficult jobs that we all have here. This case is tough enough without the sensationalization that is the potential of the media. And we certainly don't need any more drama in this case. Thank you, Your Honor.
All right, thank you, Mr. Archibald. Mr. Wood, if you'd like to offer the state's concurrence at this time, you do so.
Thank you, Your Honor. Anytime we're here dealing with, I guess what could be termed a tangential issue of the case, I do always think it's important to remember exactly why we're here. And we are here because Chad and Lori Daybell have been indicted for the murders of Tyler Ryan and J.G. Vallow and Tammy Daybell. They have a trial set for that in January, and as Mr. Archibald has stated, they are entitled to a fair trial. And as he stated, even prosecutors who have the job of seeking a conviction also have the job of seeking a fair trial for the defendants and for the state. And this court has recognized the state also has a right to a fair trial. And what that means to the state is we want a trial that we only have to do once, where we limit appealable issues. That's important not only to prosecutors, but for the people of this state, specifically the people of Madison and Fremont County, for the living victims of this case, and to the state, people who deserve that the most are Tyler Ryan, J.G. Vallow, and Tammy Daybell. So, what the state is not going to, you won't hear the state, or I think anyone argue today, that the media or public shouldn't have access to the courts. They should. It's an important right. The state believes in open proceedings. We strongly support and believe in the media's right to access and report court proceedings, and that has a long-standing history in case law. In regards to the last hearing, I want to be clear that the state is not alleging any malicious intent on the part of any member of the media. At some level, though, that is irrelevant to the consequences. The state does agree that the coverage did appear abnormal in the uneven distribution of where the cameras were focused. We think that actually has a chilling effect on future witnesses, both for the state and the defense, to know that they will be subjected to such public media scrutiny. Mr. Archibald mentioned the microphones on the council table. We think that has a chilling effect on council, so we're glad they're not here anymore. It's difficult to communicate with those microphones there, and it makes it more difficult for the parties to effectively litigate if you have to worry about someone else listening in. I would just note those microphones are not needed. There have been multiple broadcasts of court proceedings where they just lifted the audio from the court, and that has always worked fine. As Mr. Archibald talked about, venue has been changed to Ada County. At the change of venue hearing, the state presented evidence that Ada County is the largest media market in the state. We still believe that's the case. And to the state, this raises the question, if we change venue largely because of pretrial publicity, but then continue engaging in pretrial publicity while going to the largest media market in the state, why do we change venue? Now, we respect the court's decision to change venue. We understand it. So I'm not asking that dismissively. But at some point, if the rationale for changing venue is pretrial publicity, we should limit pretrial publicity. The state is actually, at this point, even more so than the trial, concerned about the next few pretrials we'll be doing. The state intends to file a 404B motion. The defense has a bill of particulars motion. These are both going to be fact-intensive motions, deal with a lot of facts of the case, need to be litigated. And again, the media has a right to be there. They don't have a right to broadcast it or have cameras. And the state believes there's a stark difference between watching a live or video of a proceeding as opposed to reading a report on it in a newspaper. One area I do disagree with Mr. Archibald. I do not believe removing cameras is drastic. The Idaho Court Administrative Rule 45 makes it clear it's at the discretion of the court. When something is so easily at the discretion of the court, I don't believe it's a drastic remedy to remove video cameras. There's some law on this issue I'd like to quickly address that was not in the state's memorandum. And there's some bright line rules here. I'm actually going to start with Richmond Newspapers versus Virginia, and that's 448 U.S. 555. And that case actually stands for the right that the media does have to access the courts. And I'm just bringing that case up because I want to reiterate that we do believe the media has a right to be here. Nixon versus Warner, 98, Supreme Court 1306. I'm just going to read a quote from the Supreme Court there. It says, while the guarantee of a public trial, in the words of Mr. Justice Black, is a safeguard against any attempt to employ our courts as instruments of persecution, it confers no special benefit on the press, nor does the Sixth Amendment require that the trial or any part of it be broadcast live or on tape to the public. The requirement of a public trial is satisfied by the opportunity of members of the public and the press to attend the trial and to report what they have observed. And so what we can take from that case, there is no right, and our administrative rules back this up, there is no right to a video camera or a camera in the courtroom. And the last case I want to address, Your Honor, is Estes versus Texas, and that's 381 U.S. 532. Now, if you're going to talk about Estes, I have to acknowledge that there's been a lot of distinguishment on Estes. One, it's from 1965. What's interesting is that the Supreme Court in that case acknowledged that that would happen as technology changed. And in that case, they were about to start a trial, and they had a 2-day pre-trial hearing on the issue of cameras in the courtroom. And so while this case can be distinguished in many ways, I think the central holding here is very applicable in this case. It says pre-trial can create a major problem for the defendant in a criminal case. Indeed, it may be more harmful than publicity during the trial, for it may well set the community opinion as to guilt or innocence. Though the September hearings dealt with motions to prohibit television coverage and to postpone the trial, they are unquestionably relevant to the issue before us. All of this 2-day affair was highly publicized and could only have impressed those present and also the community at large with the notorious character of the petitioner as well as the proceedings. I think that's directly on point with what we're doing here. Pre-trial publicity that makes a fair trial for both parties more difficult. Now, this is not the first time I've asked that cameras not be allowed in the courtroom related to this case, or at least to the facts around this case. In the concealment case, in order to prevent extra publicity, I asked the magistrate court to disallow video and broadcast of the preliminary hearing. At that time, both Mr. and Mrs. Daybell's attorneys argued that the hearing should be broadcast. I would note that Mrs. Daybell now has different attorneys. In that case, at that time, and in that case, we were in a COVID lockdown, and the court made a policy decision that broadcasting was the only way to have the courtroom open to the public due to COVID restrictions. But we no longer have those restrictions. And so the state and defense are now both asking the court to limit video cameras and broadcasting. Clearly, both the state and the defense believe that continuing to videotape and broadcast these proceedings creates a large risk of unduly prejudicing the parties' rights to a fair trial. In balancing the state's and defense request and the media's objection to that request, the court does not need to do a balancing of rights analysis. The media has a right to be in the courtroom, but there is no right to video, there is no right to a camera, there's no right to broadcast. The state and defense are asking the court to limit the risk of further pretrial prejudicial publicity without harming or infringing upon anyone's rights. And we know that the media doesn't like that request. We're aware that many of the people that Ms. Blake and I represent probably don't like that request. We're aware that some of the victims in this case don't like what we're requesting. And we respect that. But to us, the primary issue, and I think the primary issue before the court is, how do we get to a fair trial? Mr. Archibald did make a very good point of the cost of the pretrial publicity is imposed upon the counties of Fremont and Madison in terms of moving the trial to Ada County. There's a lot of extra cost, and if we have to do it again, it's going to be even more cost. Your Honor, I would note, there's been a lot of issues with trial publicity in the last year. I would note that the judge in the Kyle Rittenhouse case very publicly stated that he would think long and hard again about allowing cameras in the courtroom. He expressed that normally he supported that, but when he saw what was being done, he used the words, "It's really quite frightening." And so the question before the court is, that we're asking the court to answer is the pretrial publicity worth the risk of harming both sides' right to a fair trial? We submit that it is not. Is the pretrial publicity worth having a second trial? We propose that it is not. I would like to put the focus on the case where it needs to be, on the victims, on the defendants, and on obtaining a fair trial. And so, again, we join with the defense in asking that the video cameras be removed from the courtroom.
All right, thank you for your arguments in support of the motion, Mr. Wood. Mr. Wright, at this time, court's allowed to permit you, on behalf of your clients, to come and make a statement for purposes of this issue in this case. Can you identify yourself on the record, of course?
Thank you, Judge.
You've got and your clients, please, and then you can commence your argument.
Do you want me to list all of the clients from the caption?
If you would, I appreciate that, Mr. Wright.
So, thank you, Your Honor, for allowing me to appear. My name is Steve Wright. I represent who I have identified as interested persons, primarily members of the media. And they are specifically EastIdahoNews.com LLC, Court TV Media LLC, the Associated Press, the McClatchy Company, DBA, the Idaho Statesman, KSL.com, a subsidiary of Deseret Digital Media, KTVB TV, a division of King Broadcasting Company, KUTV, KMYU, CBS Broadcasting Inc. on behalf of CBS News, 48 Hours, Dateline, NBC News, Adams Publishing Group, DBA the Post Register, Sinclair Broadcast Group, KBOI and KYUU, Cable News Network Inc., commonly known as CNN, KIFI ABC Idaho Falls, MIFI CBS Idaho Falls, KXPI Fox Idaho Falls, KPVI NBC Pocatello, KIVI ABC Nampa, KNIN Fox Nampa, KXNN ABC Coeur d'Alene, KLEW CBS Lewiston, KXLY ABC Spokane, KMVT CBS Twin Falls, KBOI FM Boise, KIDO AM Boise, KVLI AM Idaho Falls, KID FM Idaho Falls, KBAR AM Jerome, KHTR Lewiston, KOZE Lewiston, KEGE FM Pocatello, KWIK AM Pocatello, KSPT AM Sandpoint, American Broadcasting Companies Inc., DBA, ABC News.
All right, thank you for going through the list there, Mr.
In no particular order, I might add. So.
Very well.
Thank you, Judge. And I appreciate the court and recognize that it's the court's discretion to grant leave for me to present argument here and to respond, just as it is the court's discretion under ICAR 45 in responding to the motion of the defendant, which has been joined effectively by the state. Your Honor, the first thought that I had as I listened to the arguments is I recognize and respect that the job of the attorneys for both parties is difficult. It hopefully goes without saying that the defendant has constitutional rights that must be recognized. I reject the argument, however, that those rights have been or will be compromised by following the orders of this court. And that is precisely what has happened. That is precisely what occurred on August 16th, the hearing specifically complained of, including the location of the cameras and the location of the microphones. Now, one party seems to apply nefarious motives to the media. The other seems to be more concerned about addressing pretrial publicity through this motion. We believe both are in error in the way that they are trying to accomplish it for a couple of fundamental reasons. Number one, the actions of the media on August 16th were in complete compliance, pre-approved by court personnel with the orders of this court. It is regrettable that counsel feels misled that they did not notice the microphones, but they were approved first and foremost. And the same is true with the location of the cameras. I would add, Your Honor, that multiple cameras in the courtroom are actually an important part of fulfilling what we understand to be the court's appropriate desire to balance. And make no mistake, it is important to balance without sacrificing constitutional rights in any capacity. It is important to balance these sometimes competing interests, or more accurately, competing desires. It is easy to say, as important as it is, that the defendant's constitutional rights are somehow jeopardized by broadcasting these proceedings. How? There is a significant difference, Your Honor, in telling this court that this courtroom should be open, but only to people who physically want to come and sit in the courtroom. Because if it's broadcast to other people, her rights are now jeopardized. The only rationale, the only logic behind that is to suppress information. And
I disagree with you, Mr. Wright.
Okay.
I disagree with that assertion.
I'd be happy to respond, Your Honor.
Okay, because public access is allowed.
Yes.
The sensationalism of the case is not necessarily within the bounds of what access is permitted under our criminal rules and under the constitutional right of the public to attend. And the argument made, Idaho does not have a rule that requires the courtrooms to have cameras. It's discretionary with the court, and this court makes that decision. And if I decide we won't have cameras, then people come in and watch like they have since these courts were started back before cameras even existed and televised proceedings were able to occur. And at some point, if there is so much saturation that it presents a presumption of guilt, this has been argued, I think that's entirely possible to happen in a case, and I'll just tell you I'm quite concerned about that happening here. You've named off 35 major media organizations, which tells me that there is a huge interest in putting all of the information out to as many people as possible, and we are trying to get this case to trial with a jury. And I'm just telling you my thoughts on this. I'm very concerned that this goes beyond access. This goes to creating a financial enterprise that revolves around this case. And that's not my primary objective here. My objective is to ensure that there's a fair trial for these defendants. And so you can continue with your argument, but I will tell you I disagree with that last comment you made.
Well, and I appreciate that, Judge, because I may have suggested inadvertently something that I was not attempting to do. I'm not in any way suggesting anything other than what ICAR 45 requires. I'm not here to argue that somehow this court has an obligation to allow this. The rules are clear. That's not what I was trying to express, and I apologize if that's what the court interpreted. What I was trying to say, Your Honor, is that the court has balanced these competing interests. And I'm also not trying to say that somehow constitutional rights take a back seat. But there are assumptions made here that are concerning to me and that I frankly think are inaccurate. The issue of pretrial publicity, this court has addressed already and will continue to address. I understand that. But the reality is, pretrial publicity is a result of what the state has charged and the circumstances on which they base that. Pretrial publicity is not going away. So what is being challenged here is the idea that by allowing or by banning cameras from the courtroom, that it will somehow do away with pretrial publicity. My point, Your Honor, is I don't know how that can happen. And the point that I was leading to was, Your Honor, which is a more accurate description to the public, which is indisputably interested locally.
Let me ask you a question.
Sure.
And I have not reviewed the video, and I will do that.
Certainly.
And the parties, and I'm referring to the video, it's the link in a footnote in the state's response page of the last proceeding. But if as counsel argues that while arguments are being made by the attorneys, which is what's happening in the case, while that's going on, all the public is seeing is the face of the defendant, then how is that accurately portraying what's happening in the case and not just sensationalizing the case because you're ignoring what people are saying? They can listen to it, but you're not putting the camera on who's talking. You're putting the camera on the defendant. So as they've argued, and I'll confirm whether or not that's the case, the public can gauge every single reaction of her while things are being said. How is that providing accurate information more than focusing on what's being said in the actual record of the case by the lawyers?
And Your Honor, my purpose is not to bootstrap myself into arguing specific camera shots at specific times. My point is, and is to concede that this is within the control of the court. we reject that there was a nefarious motive or even action here because we just complied with what we were approved to do. Now,
And I completely agree with you on that point, Mr. Wright. I want to make clear, I have found nothing to indicate that any of the media outlets in this case have failed to comply at any time with what they were allowed to do. I guess what I'm looking at this point is the result of what the current order indicates they are allowed to do and whether that needs to be restricted. So I do want to make very clear, your clients have not at any time failed to comply with any court order.
right, and I appreciate that, Judge, and that is important. But I'm also not trying to address what's been called unfettered access. We're trying to play within the rules. And we believe we are playing within the rules. Now, within those rules, which include the discretion of the court, please understand, I'm not trying to argue for the contrary. Within the rules, if the court determines a different location, somehow the process needs to be altered in some way, that of course is also within the court's discretion. I do take issue with the idea that because the media has followed the rules and because there was viewing of concern, and we all know that the defendant's reaction to the proceedings is of public interest. Now, whether the court feels that too much of that occurred or not, again, we just want to play within the rules. So, but what I'm hearing is not that. What I'm hearing is, despite the actions of the media as approved by the court being unsatisfactory, even concerning to the parties, cameras should be banned, period. And the point that I was leading to, Your Honor, is because of the pretrial publicity, which is not going away, which is more appropriate? An actual showing of the proceedings themselves under whatever rules the court determines. And I will come back to that because there are some reasons for why multiple cameras are better and fulfill the decorum of the court that this court has every right to demand and expect. But is it better to allow the proceedings to be shown in addressing pretrial publicity, or is it better to require someone to be physically in the courtroom so that they have to report on the proceedings? There was nothing about the actions that day that interrupted the decorum of the court. And it was showing, perhaps in a way that the court will adjust, but it was showing what was going on there, including the defendant's reaction. That's my focus, Your Honor, is what we believe is an inappropriately extreme response to actions that were permitted by the court, as opposed to the court just continuing to do what it has done, and that is balance those interests that it recognizes and continues to address that in the way that it deems appropriate. Does that make sense, Your Honor?
It does.
I did not mean to suggest that this court had to do something different, but I do not apologize for the importance that the role the media plays in this, and it is easy to throw out terms. I'm not suggesting whether it's done here or not is up to the court to determine, sensationalizing or circus or whatever, in a proceeding that is just like this, except that it had microphones and cameras in places that were approved beforehand. Your Honor, there are some technical reasons that I think it's also important that the court understand. And again, I hope it's clear, there was no intent to mislead. We just placed them where we were told we could. Now, as far as the microphones go, I'm advised that microphones, and as I believe the court knows, Court TV was the pool, providing the pool coverage that day. They have perhaps abilities and capabilities that local media, such as East Idaho News, who has also provided pool coverage, does not have. The locations of microphones and cameras today was first and foremost approved by the court, but also it is the resources that East Idaho News has. Court TV had additional resources, and that includes specific and precise microphones. It is important to understand, I guess first of all, I will offer this, Judge. Court TV has the ability to provide mutable microphones. However, I also believe that argument is a little bit misleading, because the argument is made that if somebody is arguing at the table and there's a conversation next to them, that this system, the court system, could be muted to avoid catching that. But you can't do both at the same time. You can't make an argument over the microphone in counsel and mute the microphone if there's a conversation here. That's why the level of effort is put in by the media to comply with the court's order, not to find ways around it. There was that day a technical, at least one technical person, perhaps one audio, one visual, I'm not exactly sure, in real time monitoring so that if a whisper is heard, and frankly, and if they don't know where it's coming from, all the mics get shut down. But if they...
But that person, let me ask you something on that, Mr. Wright. Sure. We deal with officers of the court who have all of their responsibilities and duties to the court when attorneys are up here. We have clients who have the right to remain silent. What is being suggested here is that a technical person who has some training, I don't know who they are, I don't know who they're employed by, I don't know who pays them, and the suggestion that we outsource the recording outside of our own court-approved system to a third party under the good faith that they won't leak anything out if they capture the wrong thing being said, like a privileged attorney-client communication. I find that a very concerning proposition, and something, quite frankly, I can't imagine I would continue to permit, because the issue brought up by counsel about the ability to be able to have unrecorded private conversations during a hearing is fundamental to the defense of this case, and it's also fundamental to the state in order to present their case. And so no matter how highly trained or technical these people are, they're not court employees, they're not court personnel, they're not subject to all the rules that a lawyer would be subject to. And if they go outside of the scope of that, this information gets leaked and blasted out to, as Ms. Wong says in her affidavit, millions of people, then the bell has been rung, it can't be unrung, and we could end up with a mistrial in this case, or other consequences. And so it's a huge concern to me, and I'm just telling you, I'm not inclined at all to outsource the important responsibility of a recording to a third party with just an understanding that they're trained and they'll do the right thing and trust us.
Well, and I appreciate the court sharing its perspective. I guess I don't see it that way, and perhaps I'm missing something, because when the court grants what it grants, as far as cameras and microphones, I realize two different issues, but related. In the courtroom, it is not simply reliance on in good faith. I understand the point about if that happens, then it's out there. But there is a distinct party that is subject to the jurisdiction of this court to pay the consequences of such an action. It is not simply a reliance on good faith. They're submitting themselves with that approval to the orders of this court and the ability and the consequences for failure to comply. I know there is a temptation, not necessarily by the court, but I know there is a temptation to assume the media is simply out to get whatever it can get. This is not, and of course I don't speak for all media. I speak for my clients, and I in particular speak for those who have been granted or even will be granted pool coverage. These are professionals. I understand, I'm not trying to quibble with the court's point about there's still third parties, but these are professionals whose who are among the best at what they do in difficult situations like this. The arrangement that was granted, as Ms. Wong states in her declaration, is not unusual. That doesn't mean this court is in any way bound by it, but it's not like this court is just turning over control and hoping things go well. There are professional and very directly judicial consequences if they don't follow the law and the orders of this court just as much as anyone else here. So I do respectfully disagree that this is simply a matter of turning it over and hoping things go well. And indeed, I would respectfully submit, Your Honor, both with regard to cameras and with regard to the microphone, that these microphones are more capable of siphoning out inappropriate information. As the court knows, and I stand corrected.
Who determines what the inappropriate information is? Do I get to make a determination on that? Does counsel get to weigh in on that? Or does someone that works for one of your clients with a set of headphones on make that decision? And I have no idea what their training is or understanding of the rules of evidence or the rules of privilege that exist amongst attorneys and their clients.
Well, respectfully, Judge, I don't think it's that difficult. Any communication at the table is confidential. Any notes on the table are confidential.
That's also not true, Mr. Wright, because clients can talk out loud to attorneys, and if they do it in a public setting and everyone hears it, and I've seen it before in criminal cases.
Sure.
Defendant blurts something out to their lawyer. I hear it. State hears it.
Right.
They shouldn't have said it. They waived the privilege.
Sure.
So I would say there is a determination that needs to be made each time. And again, these are decisions that, how am I to have faith and confidence that whoever's making that decision is making the correct legal decision?
Well, perhaps the court can help me understand. I'm a little confused by the example, because if the defendant...
Just point out, you said all communications are confidential or privileged, and they're not necessarily. That's not always the case.
Well, that's fine, but that's not the point. If my clients treat those... I mean, if something is blurted out and said, it's heard. It has nothing to do with whether the media had something to do with it or not. My point is that it's treated, those communications are treated as confidential, period. Period. There isn't a determination to make, oh, maybe we can listen in on this one and not that one, period. They are confidential.
So that's a standard your client implies. Is that a written policy they have somewhere, or is that your representation after talking to them? Or how
okay,
do you know
thank
that's
you.
how they're determined?
Thank you, Judge. And it's a representation I'm happy to make after communicating with them,
Okay.
and would be happy to make or submit a declaration or affidavit to that effect. That as far as the cameras go, I want to make sure I'm tracking with the court's concerns, because that's what I need to address. But as far as the communications go, other than a concern that something might be overheard, that we are affirmatively telling the court will not happen. And the training, and it's not just some training, it's better training than I could do. That's their purpose. The reason for being here is to ensure that we comply with the court's order. And communications at the table are treated, maybe that's the better way to say it, treated as confidential. If they blurt something out, that's beyond your or my control. But they're treated as confidential. They are not recorded. What the court hears when it reviews that the broadcast that was submitted, I believe, by the state, it will hear what was recorded. It's the same thing. There's no editing. There's no filtering, because all of the effort is placed here in the courtroom to ensure that compliance. Does that help the court?
It does, and I do appreciate the way you answered and your responses to my questions, Mr. Wright. I'm not trying to go after you here. I just have some very real concerns, and I do appreciate the way you responded.
Of course, because if the court has concerns, I want to address them. I totally agree. I take no offense and certainly hope I haven't argued with the court at all. My goal has truly been to respond to those concerns. But those concerns are based on what we think is an overbroad approach to shut down pretrial publicity and frankly to accuse the media of some wrongdoing that it simply didn't do. If the court, we have no objection to the court reviewing. It's open to the public. The court should, of course, be able to review that information. That's its very purpose. And if the court sees, I have a concern. I have a concern that too much focus was on Ms. Daybell, or even that the camera was located where it was. Again, the point is it's within the court's control. We just ask that the court continue to exercise the control that it has. The arguments, at least in part, seem to assume this court isn't in total control and these things are just kind of happening, or more importantly, might happen. And that's simply not true. This court, the media will follow what this court directs, of course. If I may just look, see if I have any other comments for the court. I may have a moment. Well, I'm not sure if I addressed this, Your Honor, more of a technical aspect. With regard to multiple cameras, again, the goal is to avoid distraction. So the reason for multiple cameras, whether it be 2 or 3, we respectfully submit 2 or 3, especially as they are used, it does not create a distraction. And the reason for that is our goal is not to move them. And so if the camera is showing something and say a confidential communication occurs, I've addressed already how the microphone it is shut down. And again, what happens, what's recorded is what's broadcast, so the court would know if there's a problem there. But that allows us the ability to immediately go to another camera, taken off whatever might be a confidential communication or whatever the court determines is inappropriate. And so there is actually, where possible, a need for multiple cameras because we don't, I'm sure the court doesn't want to see distracting cameras panning or moving around, and yet we need to be able to get off whatever it is that might be an inappropriate thing to show. So I hope from a technical standpoint that provides the court some guidance as well. And recognizing the court's concern about third parties' involvement, I want to point out that if the court's sound system is used, if anybody says anything into the microphone, it's picked up for better or worse. We actually have the ability to control and make sure that doesn't happen. It also, and I don't know about the quality here, don't mean to impugn it at all, but the quality of the audio is important. FCC standards require a certain level of quality for closed captioning, things of that nature. And again, these things can all help facilitate what we believe is the court's correct balancing of these interests. When I say balance, please don't misunderstand that I'm trying to say somehow the defendant's rights need to be sacrificed. What I'm saying is they can be balanced without sacrificing those rights, and I respectfully submit that going to the other extreme of banning cameras from the courtroom, whatever the court might do or was requested with regard to microphones, actually interferes with that rather than helps ensure the decorum the court demands it is in fact respected. Did I mention if at least Court TV has the ability to provide mutable microphones if that's something that the court wants. would suggest, Your Honor, not that this, I don't know what relevance it has to the court, but we respectfully disagree that there was some unusual happenings that occurred. For a high-profile matter, even the camera placements and the microphones, as Ms. Wong states in her declaration, who's been involved in many of these matters, was not unusual. And that isn't somehow binding on the court, but I just want to respond to this idea that what happened on August 16th was an atypical situation. It was a typical situation for atypical circumstances, if I may put it that way. I guess in conclusion, Your Honor, I am concerned when this motion is used as a means to attempt to curtail pretrial publicity, when the United States Supreme Court has indicated that there are other means to do so. And I know the court knows this because the court has thoroughly considered those issues in the decisions that it's made. The pretrial publicity won't stop. The accuracy of what happens in here or how it's reported may be hindered.
What about the volume of it?
Of the interest?
Of the publicity?
Again, I'm not sure.
In other words, if you can read about a hearing in the newspaper versus watching it live on social media, what do you think is the volume of one versus the other?
Well, I guess that's what concerns me, Your Honor, is when the purpose is to control the spigot in a way that says, well, we'll be able to tamp it down this way, because if we do it this way, more people will watch. The level of interest, it is not based on the media. It is based on the circumstances. And I respectfully submit to the court that when the court looks at trying to... Go ahead.
The media, they promote certain stories. I know this. I can have a routine standard hearing in this case and I know it goes out on tons of media outlets and it's publicized everywhere and it's promoted. And 2 weeks ago, I have a change of plea hearing in Madison County where someone pleads guilty to a murder charge. Not one reporter or that I ever saw in the local news I occasionally look at, not a story on it at all. So
Sure.
Certainly publicity and promotion of that publicity go hand in hand. And the concern here again is we're not to trial yet. We've already had to transfer venue because of the publicity and the promotion of that publicity. And what's wrong with considering that we need to try to control that so we can get a jury pick that hasn't already made up their mind and make us have a mistrial for not having enough jurors that haven't already been tainted by pretrial publicity.
Well, of course, the court is correct in its concerns, and I don't have any argument with that. My concern is in the way that the court's concern is addressed. Simply assuming that because there is publicity, even internationally, an Ada County jury can't be found, I think is a reach. Other than just the general premise that the more people hear about it, the more possible it is that there will be people that have prejudged the case. That's like taking a sledgehammer to an issue where a scalpel is appropriate. And so I recognize the concern. Do not quibble with it at all. My concern is with the manner in which it is addressed. And I do respectfully come back to the idea to say, well, if you want to know about this case firsthand, then you must physically come here. Otherwise, you'll rely on the reporting, which won't be as accurate by definition as the firsthand experience, which is within the control of the court. Have I responded to the court's question?
You have.
Okay. I appreciate again the court's time. We respectfully request that this motion be denied because the power always has been within this court and has been appropriately exercised. And if the court determines There's an adjustment on fine tuning some of the things that it will permit. We respect that. Our concern is what we think is a vast overreaction to appropriate approved conduct of the media that will hinder what we still feel is an important function that doesn't have to be sacrificed to ensure the defendant's constitutional rights. Does the court have any other questions for me?
I don't, Mr. Wright. I appreciate your professionalism in your arguments today and responding to all the questions.
Thank you, Your Honor.
Counsel, Mr. Archibald, Mr. Wood, the court engaged in quite a few questions with Mr. Wright and indicated some of my expressed concerns here. If you'd like, I would offer you an opportunity to respond. I guess I'd label that as a rebuttal argument if you'd like to what Mr. Wright's offered here. Mr. Archibald, is there anything further you'd like to add?
Just briefly, Your Honor, the media's argument that we were in compliance with the court orders is exactly the problem, because the orders weren't specific enough as to what they could do and not do. So we let them police themselves, and when we let the media police themselves, what did they do? They put microphones on our tables, put a camera right in front of us. That had not been done in any other hearings, which I have never seen. And so that's why our motion to clarify is so that the court can, as Mr. Wright suggested, take a scalpel to this order and say no cameras zooming in on the defendant, no microphones on the table, no live feed. The court does have the discretion to modify these current court orders. These current court orders are forms. They're used in routine cases. And again, I've never had to ask for a modification because we, in the past, have been respectful of each other, and they just crossed the line last hearing. That's why I brought the motion.
All right, thank you, Mr. Archibald. Mr. Wood, would the state like to offer any rebuttal?
Just briefly, Your Honor, to the state, compliance isn't the issue. It's just it affects back to trial publicity. At one point, I think Mr. Wright did say that the harm was an assumption. Well, it's not an assumption. The taxpayers in Madison and Fremont County, we're paying a lot more for this trial because of pre-trial publicity. That is not an assumption. And so I do take issue with that. I won't comment on the issue with the microphones anymore. I think the court's comments show that it understands at least our concerns. I guess the only thing I would add is if the state still believes that the best remedy is simply to remove video cameras from the courtroom. If the court decides to take a different approach, we would request that the state and the defense be put on notice as to the location of the cameras before any hearing takes place.
All right, thank you for your comments, Mr. Wood.
I just can have permission to be excused unless the court was going to rule from the bench.
I don't intend to rule from the bench, Mr. Wright, so you may be excused. Thanks for your appearance.
Thank you, Your Honor.
All right, counsel, I've considered this issue needs to be taken under advisement because it would result in a ruling regardless that would have a future effect on how these proceedings take place, and needs specific instruction on what we will or won't allow in terms of cameras and microphones by third parties in the courtroom for future proceedings. I'll be considering that both in the context of pretrial motions and the trial itself. I'll carefully consider these issues that have been raised, and the court will issue a written decision. I think that concludes our hearings for this morning. And Mr. Archibald, anything further from the defense?
No, Your Honor, thank you.
Mr. Archibald, Mr. Wood, anything further from the state today?
No, thank you, Your Honor.
Okay, thanks everyone for being with us.
All rise.